This is an exact product of what the state has set up. This is the exact view that they want people to have, and whatever he's seen, this is what they want him to see. Because the way he explains this is just, this is exactly the type of person they want to judge Lane in his case.
Lane Myers an admonition that if he doesn't maintain decorum, that he will no longer have the privilege of representing himself. He will be assigned a public defender to represent him, the public defender who's been his elbow counsel essentially to date. The other big issue, the other thing of note was that Lane Myers wants a plea deal. So for all of you people who are like, oh, you know, he plans on losing at court and then winning on appeal, because everybody knows you lose in court and then win on appeal. Well, tell that to Earl. It is a bad plan. Anybody who tells you that the plan is to lose a trial and win on appeal, that's a bad plan. Attorneys don't try to lose a trial and then win on appeal. You try to win at trial, because if you win at trial, the side that appeals is probably going to lose on appeal because you've already won at trial. Your odds of winning a trial, 50-50, give or take, you know, whatever. Your odds of winning on appeal, 10% maybe? I mean, I'm talking like average. Your odds of winning beyond that, 5%, 4%, 3%. Ultimately, whatever deal gets reached has to be agreeable to the prosecutor. And also will have to be agreeable to Lane Myers. But, you know, there you go. The prosecutor has really all the cards on this. Oh, and it's also probably going to have to be acceptable to the victim. The victim has been at every hearing as far as I'm aware. The victim is taking an active interest in this. And, you know, this is really the find out stage. Like everything that Lane Myers has done has been just bad take after bad take. Going after a city prosecutor's wife and then going after the prosecutor. I mean, you might think he has the right to do it, and he does, but you got to understand that she's human, and she's probably going to think about the videos that he made about her when she's thinking about crafting the plea deal. And she's also probably thinking, you know, I understand what that city prosecutor's going through. He's kind of like a comrade, you know, a contemporary, a fellow, you know. I can understand what he's going through, having his wife treated like this. And then the wife is there, the victim is there, who's saying like, I've been enduring this crap for half a year or more. You know, at some point, it was just too much. And so all of Lane's actions are going to figure into the offer that the prosecutor gives. Because I get the strong sensation from this prosecutor that she is absolutely ready to take this thing to trial. She's got him dead to rights. He posted the harassment. She just has to use his videos. There is no easier case for her to win. I know everybody's like, it's free speech. No, this is a slam dunk, folks. Like, when I'm saying that he's probably going to get convicted, he might be able to pull an argument out of his butt that something or the other, that what he said to get rid of one or two videos. But there's just a chain succession of videos. The guy had motor mouth. He couldn't stop. He made too many videos. He incriminated himself too much, too many times. He might get rid of one or two, but you're going to get hit, bro. You're going to get hit. So if this goes to trial, it's all bad for Lane. You know, the judge might take mercy and give him a light sentence. The judge could do that. But Lane's already been shitty. Lane's already done the things that might have prejudiced the judge. No, you can't. You're not supposed. Oh, the judge is prejudiced. He's biased. Now you got to get rid of him. No, Lane did the things in his courtroom. Lane did the threatening eyes or whatever. Apparently the threats were the looks that Lane was giving the judge when the judge was saying, you're threatening me. It wasn't what Lane was saying. It was the looks that Lane was giving that were imparting a threat. And the judge gets to think that. The judge's opinion is the judge's opinion. And the judge is going to have that opinion when he goes to craft any sentence. I mean, it's like, this is just find out stage. We're really in find out stage. But at least Lane understands the
Real quick before I break it down, the looks were what was threatening. Okay, and what can't we see? The video. They only approved audio, and it's Lane's looks that are now what's threatening and menacing and harassing. Give me a break, dude. Think about that. If that was the case, then why wouldn't they want to show the video and show how angry and whatever, how harassing his looks are? And his looks, Lane is blind as a fucking bat, dude. I don't know if y'all have noticed that. He is fucking blinder than shit. And I bet he was sitting really, really far away, right? I mean, we don't know because we don't have video, but his looks are him trying to focus. That's a fact.
That position he's in.
Well, first of all, the judge shouldn't have any opinion because it's too early to have an opinion. And if it's a jury trial, the judge doesn't have one, period. His only opinion should be whether something is admissible that the lawyer said or to overrule an objection. His opinion should be neutral. But anyways, let's start at the beginning of what this guy said, because he is a perfect example of what the state wants people to think and act and be like. They want to view, his view is the way that they want it to be viewed. But here's how it really is. So, okay, so we're gonna address the things he said starting at the beginning. Okay, we're gonna start with this assertion that if he can't maintain his decorum, that he is going to be assigned a public defender. Okay, they decided he was going to have this exact public defender in December. Watch. My whole point for this video is to show that this isn't some random thing that's happening, right? It's exactly the way they want it in every way. For example,
he will no longer have the privilege of representing himself. He will be assigned a public defender.
See, you think, and everybody else does, because of this, because of his whatever behavior, that he will be assigned a public defender if he keeps acting this way. Well,
to represent him, the public defender who's been his elbow counsel essentially to date.
I'm glad he said the word to date, even though that's vague and I don't know what that means, but he means up until this date. Well, speaking of dates, he was assigned in December. Watch.
Wait to speak until called upon by the court. Mr. Myers, you're leaving a warrant is going to issue for your immediate arrest.
Are we having a hearing today or letting you talk all day? Because I got a hearing at 10. I have another hearing at 10. You're wasting my time.
Again, Mr. Myers,
This isn't your world. This is your courtroom. Where's the Zoom? Why can't my family
of the court.
Why can't my family be on Zoom right now?
Explaining what the rules are.
There's no rule that my family can't attend on Zoom. Keep going.
Myers,
Let's
if you
go.
keep interrupting, I'm going to hold you in direct contempt of court.
You don't scare me, bro. Let's do the hearing.
All right, I'm holding you in direct contempt of court this time. If you can take him into custody, I'm going to, in the interest of justice, I'm appointing you as Mr. William Parvin to representing you as Mr. William Parvin to representing you as Mr. William Parvin to represent.
So, Mr. William Parvin was actually appointed to him December 5th. But you know why that nobody sees this one or why this video wasn't used in any of the things? Is because this video wasn't broadcast he didn't allow any filming in the courtroom. And then he said everybody could get on Zoom, but then when it came time to sign into Zoom, I couldn't get on. Nobody could. His family could, nothing. An in-person hearing just means that Mr. Myers has to be in person. It doesn't mean that it's in person and that there's no transmitting or broadcasting. That's not what it means. He kept saying it's in person. In person does not mean it's not broadcast. It just means that the person that's there has to be in person. Anyways, that's why nobody has seen this. This is the only recording of it. Okay, right there, Judge Ball admits that he needs to set a hearing on the sentencing for the direct contempt, but he just sentenced him to jail for the direct contempt. He knows what he's doing, and he didn't want this to happen live on Zoom where there's video proof of it. So this is the only recording of it. Now, how did Mr. Myers come to interrupt him? Well, again, this is all to show that this is all set up the way they wanted it to be. But during Judge Ball's reading of the rules, he said that if you want to be heard, have a seat. But if you want to be heard, then stand up silently, right? Okay. Here's Mr. Myers, though, before I show you that. Here's Mr. Myers when he got out of jail.
In jail, and the next judge was like, get him out of jail immediately. when I got to the jail, they didn't even know what to put in the computer because you're not even supposed to go to jail for contempt. And I got something for your ass, Rich, Tracy, and Brandon, too. You stupid motherfuckers are the first name on the fucking lawsuit for participating in my fucking kidnapping. I was supposed to be taken in the fucking back and issued a show cause order under ARS 12861. And you motherfuckers knew that, and you let them take me to fucking jail and put me in that fucking jail on the wrong fucking charge. I was supposed to be cited and fucking released on a class 2 misdemeanor under CR 35 fucking ARS 12861. And you
Okay, so they sent out everybody a Zoom link on the day of this case, and then come to the day, the second the hearing starts, the Zoom doesn't work, right? And then he gets held in contempt and arrested under contempt for a non-arrestable contempt charge, and then gets put in jail, and the jail can't even put him in because they have nowhere to put him. But the only thing that comes out of this that's legit, there's no video of this except this, and there's no official video record of it or anything, and there was no contempt hearing held afterwards, no sentencing hearing. Nothing was legit except the appointment of William Parvin. Really? Come on.
Freedom of speech to prohibit their use in the courtroom.
Right there, he should have been scared, dude. This judge literally just said it doesn't abridge your freedom of speech to prohibit the use in the courtroom. That is the very definition of abridging something, to shorten or to give him less options, to make less than. He's literally giving the definition of abridging by saying the word prohibited. You can't say that something is not abridged and then say it's prohibited a little bit. That's contradicting. That's like saying that's a truck. That's not a truck.
Courtroom. Any suggestion to the contrary is not rooted in facts, logic, or the law. Further, as a judicial officer, I have an ethical obligation to ensure that my presiding over these proceedings does not give off even the appearance of impropriety. To that end, there was a material misrepresentation.
Here's another thing that happened that nobody even notices, but he starts to talk about the rules, and he says if you want to talk, stand up. And then so as soon as Mr. Myers stand up, he says, "Sit down, Mr. Myers." He's literally telling him he can't say anything. But doing so by trying to make it seem like he's breaking the rules of decorum by
Parties will speak directly to the court. They will not speak to each other. Only one person shall speak at any given time. When the court is speaking, everyone else shall remain quiet. The party shall remain seated unless they seek recognition to speak from the court. If a party wishes to add to the record, they shall silently stand and wait to speak until called upon by the court.
Gotcha, ball. Stand up if I want to talk. Okay, perfect.
Judges in chambers. Mr. Myers, if you could please have a seat.
Why isn't there Zoom right now?
Because
is Mr. Myers being uncontrollable, or is it the fact that just everything around him is a lie? The only reason he's even talking is because he was supposed to be on Zoom, and they somehow shut Zoom off. So again, this is everything is, the court has set this up. They have set everything up the way they want it. Like, of course he's going to get up and say something if it's him that can't get on Zoom to watch his public hearing. This isn't even a public hearing anymore. It's literally a private hearing. Anyways, this is all set up by the court. This is what I'm trying to show. Like, I'm trying to show you this is everything that they wanted to happen happens because they did it. Not because of his decorum behavior or his lack of control.
To represent him, the public defender who's been his elbow counsel essentially to date. The other big issue, the other thing of note was that Lane Myers wants a plea deal.
No. Lane Myers wants to go home is what he wants.
So for all of you people who are like, oh, you know, he plans on losing at court and then winning on appeal because everybody knows you lose in court and then win on appeal. Well, tell that to Earl.
See, I know a lot of you can't understand this. He doesn't want a plea deal. And in fact, that's the exact opposite of what he wants. He wants his day in court. But if any of y'all have ever been to jail, you don't understand. You understand why he wants to get out of there. That's what he wants to do. He wants to get out of there. But in the meantime, entertaining the idea of a plea deal is the only way that he's going to get anything, because he doesn't have access to the law library, regardless of what they say. He can't do anything about his case just sitting in there by himself, and his lawyer's garbage, and it's appointed by the courts, and he knows that. So his only option to get any kind of information or get any kind of semblance or insight to what they're doing is to call a meeting with her and then kind of pick her brain and kind of see where she's at. That's the only option he has. And to do that, he has to entertain the idea of a plea deal. If not, if he just says, nah, fuck that. Oh, but can I talk to you anyway? That's just like, no. He has to entertain the idea. He has to pretend like he's, that he's going to do it, entertain the idea so he can get Rachel in front of him and talk to her and try to find out where she's at.
Tell that to Earl. My stance with Earl had a good appeal, and even though it was a good appeal, the odds of him winning were very, very low. And the odds of him he's going up for apparently he's requesting a en banc hearing and or a rehearing of his appeal, and he's probably going to lose those too. I mean, just your odds of winning on appeal are super duper 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 low.
And he's right, which is why he decided to appeal it. The Shannon Walker thing, he decided to appeal it, and it's still pending appeal. It's still on appeal, and then in the meantime, he got the O'Reilly's case dismissed. So literally, all he had to do was win on appeal, and then he would have won everything. And then that's when he got the summons. Well, actually, he went to go get court records, a recording of a court record, and then they give him the summons and hit him with 14 felonies. Weird.
Let's go. Serial killer. Uh-oh. Am I free to go? And Walker. We're out here. We just filed the notice. The temporary break was because I had to go into court and file the notice. I had to file the appeal in the Shannon Walker.
This was December 10th now.
But now we're out here looking for Real Housewives.
5 days after the Judge Ball.
Mr. William Parvin to represent you on your behalf, but I will set this in front of another judge for sentencing on the direct contempt.
How is this my court hearing? Don't have me come down to that court and record you. Judge Ball, justice denied is justice delayed. Tell me about it. I just got a letter saying that I got my rights violated 7 months ago. No shit. Where was my So after 6 months of kangaroo shows, where's my justice delayed? Justice denied. When am I going to get my hearing for my contempt charge? Deterring potential criminals. The more swiftly the process operates, the more effective will be the protection of the public because the dangerous criminal is quickly removed from the streets. Also, the drafter of the rules contend, swift and certain, punishment has a greater deterrent effect. The societal interest in accurate fact-finding is similarly advanced by a speedy criminal process. The committee observed that the further removed the trial is from the occurrence of a criminal act, the less likely is a factually accurate conviction or acquittal. Thank you.
So now let's hear why the state wants to dismiss the O'Reilly's charges without prejudice. Let's hear that one. Let's hear that argument and then see what we think.
First of all, the argument is this. The state has moved to dismiss because it doesn't have an essential witness. That witness is Mackenzie O'Brien.
They'll never have it.
The state made attempts to serve her. The state was unsuccessful in both
Remember, they're calling Mackenzie an essential witness.
attempts that it made to serve her.
Can I clarify? So they keep saying the witness, it's the victim. Remember, they fought this whole time for the victim. So witness is different than victim. Remember now, a victim, you need the victim of the crime, no victim, no crime type thing. They're talking about a witness. They're saying, remember now, you told me that they could designate her as a victim, and they did with Matt Walker. They did, and I was no longer allowed to talk to her when she was designated as a victim. So it's intellectually dishonest to sit here and say that she's a witness. She's a victim. Now, whether that means that victims, police officers, witnesses are all witnesses, but do you get what I'm saying? For the context of this discussion, it's not an essential witness. It's the alleged victim.
Okay, but the state is saying that she is now an essential witness, right? Okay, so but what about back when he was talking about? Back on September 18th, she wasn't.
Because I'm suing the cop that did it, and that's her little buddy. She's an undercover informant for the Tucson police, and her mommy fucks the cops.
Stop making a record directing anything to the victim. 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 Calling the victim.
Witness. You bring the witness. Hey. All right.
Can't direct any speech toward the victim, but now in December, she is an essential witness.
Because it doesn't have an essential witness. That witness is Mackenzie O'Brien.
She's a victim whenever Lane needs to interview her, and then she's a witness whenever Lane needs to be incriminated. Come on.
They'll never have
The
it.
state made attempts to serve her. The state was unsuccessful in both.
Is you follow the law, okay? I know you work for the city. He works for the city. I'm not accusing you of that because I've only met you for 10 minutes. But I'm telling you what's been going on is sir, how would you let a case move through arraignment, pre-trial, set a trial, and then be like, oh, it's a conflict of interest, vacating the trial? Why the fuck didn't you declare it a conflict of interest before we started proceeding in the case? That's bad. Go ahead. Okay. He's saying she's the victim. He just lied to you right to your face, sir.
Either way, those cases were dismissed with prejudice. Without prejudice. I don't know, whichever one it is where they can refile. And that was on the December 10th that we've been watching. Now, June 8th of 2025 is the last day they have to refile these O'Reilly's cases against him, right? And if you remember, the judge just recently said that he's going to set the court date, or the trial date, for June 17th. What the fuck? That means that they file on the very last day and then give him 10 days that the new charges are going to hit right at the beginning of his trial for this. Come on.
For the record, we're getting the times and dates and times available for our witnesses. We'll let you know when you have trial. So how the fuck does he know his names and times of witnesses, but I haven't even received it? I'm the fucking defendant, and it's been 100 days. So he's telling the court, I have my list of witnesses, and I'm saying, yeah, it was due 3 fucking months ago. So how does he have his list of witnesses? He's telling the court he has his list of witnesses, but the defendant doesn't have the list of witnesses. How can I prepare my trial? How can I interview this moron if you fucking don't give me their name and their information as required under by law, right? So, Rule 15.1b, the state has 30 days from request. I put in a motion to compel fucking law 4 fucking months ago. They had 30 days from that motion to give me their 15-1 disclosure, witness list, all that shit. Or by the first pretrial. That's the law, sir. You follow the law. The law said first pretrial, you must receive. I've turned over all my disclosure. They've had all my Rule 15 disclosure, all my witnesses, all my evidence, everything for 4 fucking months. I don't even have the witness list. But they're
At the end of that hearing, they ordered the state to compel the witnesses, didn't allow the state to put any more conditions of release on him, and also granted him the opportunity to talk to the officers. Right. He granted everything that Mr. Myers was asking for and nothing that the state was asking for. And then Matt Walker put in a motion for him to be mentally evaluated and then recused himself or whatever and got somebody else up there. So that's what happened, right? Lane Myers is not going after Matt Walker. What Matt Walker did is took himself off the case because of a conflict or whatever. And after filing a motion to have his Mr. Myers' mental sanity checked, and then Matt Walker starts using his wife to go after Lane Myers. And the prosecution, Rachel Stiles, her plan worked because this is a general idea or thought that they have about Shannon Walker and the relationship between all of them.
She's thinking about crafting the plea deal. And she's also probably thinking, I understand what that city prosecutor's going through. He's kind of like a comrade, a contemporary, a fellow, I can understand what he's going through, having his wife treated like this.
That right there is the whole crux of this whole thing, having his wife treated like this. Look, Lane Myers' channel was started so he could show people his personal experience, what he's going through with all the law stuff, right? With getting charged, arrested, and everything. That is his thing. He wrote Matt Walker, left him a voicemail. The whole reason they even contacted her, that she even got a voicemail from him, is because Matt Walker was withholding discovery. He had called like 56 times or some shit. Anyway, he finally got fed up. He left her a message, a single message. And then she got an injunction against harassment. And that's when they had the little court hearing on it or whatever. She sat next to him, weaseled in 14 exhibits. Look, she became part of his case before everything that they say that he's harassing her about was all about the case. She made herself a part of it, right? He left one message. That's the only thing they got is one message. And it wasn't even bad. One message before she decided to make herself, before the injunction against harassment, there was one message left. Everything else has to do with the case. And in the meantime, while they were trying to make her, when she was making herself part of the case, he got two other injunctions dismissed or whatever denied because they're insufficient.
Rather than file
Think about that.
at once, where Mr.
And then, okay,
Myers
October 9th, when she actually went to go do the petition for the first one, the one that she lied about and then had to go get changed unlawfully, that day was the very day that he went down there to the office or whatever, and all he did was walk around and flirt with the lady at the front. That's it. Well, not even that. He didn't flirt with her, but you know what I mean. Like, he just sat there and was like nice to her. He didn't yell or anything. He didn't do anything to anybody. Her coworkers were like offered to bring him into her office, and he was like, "No, I don't want her to open the door and me be standing here. It'd be weird, you know." So he left. It was nothing. None of the videos, zero. I watched them all. I did zero of the videos. None of them are about Shannon Walker. None of them. So they told him to take down the videos about her. He did. There's none. Look, here is Shannon Walker declaring that because of a comment left on a video that Mr. Myers commented on. You know how long it would take her to find that, and how many clicks it would take to get there? She is following his activity on his page, which is completely lawful, writing it down, calling the cops, and then the cops are making a report out of it. It's nothing he's done is wrong, dude.
It's the comments from the YouTube video, specifically when someone asked him if they, meaning myself, and I am not sure if he means my husband.
The prosecutor has really all the cards on this. Oh, and it's also probably going to have to be acceptable to the victim. The victim has been at every hearing as far as I'm aware.
Okay, if she's a victim, then where's the witnesses and the evidence? Okay, the witnesses is her, because like all the evidence they have in record is all her, and the judge in that thing, he said, well, how do you know what this is? And she said, oh, I've seen it myself. She's the one who verified the evidence, and it's evidence that she brought to the cops. So she's the witness, the evidence gatherer, and the victim. All the videos that she claims are about her is she went and found the videos, sought out the videos, found the parts where her name is mentioned, and then told the cops about it, and the cops made a report about it, and then she is introduced it as evidence in a court hearing that she had against the injunction against harassment. She introduced all that evidence herself after she's the one who gathered it, gave it to the cops. And then Rachel Stiles questions the cop on the stand, and that's how it's validated into that court as evidence. Think about it. And then now Shannon Walker gets to be the victim, the one who turned in all this evidence. She knows what everything is because it's all gathered by her. Now she gets to sit there and watch it go down as a victim, so she can see every step of it. I think you got it backwards on who's going after who. They went after him. Right? They're the ones that are bringing him to court. Shannon Walker, the city prosecutor's wife, brought Lane to court. She's going after him. This is getting too long. I'm making a second one right after this. Y'all stay tuned. No. At the exact point of September 18th, when her husband got embarrassed in court, is when it was too much. That's when all this shit started, dude. That's whenever she started the injunction, or taking note of everything that he literally. She is stalking him.
Get the strong sensation from this prosecutor that she is absolutely ready to take this thing to trial.
Gosh, lawyers and their words. Okay, what thing? What thing are they taking to trial? Look, Lane got served with a petition for the injunction against harassment. That is the first time he heard about anything being harassing. And number two, at the contesting hearing for the injunction against harassment, she admitted that they have never communicated and never talked. How is he supposed to know that she didn't want whatever it was? You know what I mean? There's no unwanted factor here. Wanted people to keep calling so they could get Lane in trouble. They wanted this so they could give him criminal charges.